Good morning, everyone. Welcome you all to a series on related party transactions by Mehta and Mehta. So as you know, we are going to present a series on related party transactions in the next few weeks. Today, we are going to talk about concept of related party. So today we have with us CS Vallari Gupte. She is a commerce and law graduate from the University of Pune, a fellow member of ICSI and ACIS from Chartered Governance Institute, UK. She is working as a general manager, company secretary, and compliance officer at CEAT Limited. She is also a member of the ESG Council and Sustainability Task Force at CEAT, responsible for integrated reporting, and also she leads the Center of Excellence for Legal and Secretarial Functions of RPG Group companies. So she has a total post-qualification experience of around 20 years and has worked in corporate secretarial and legal functions of various multinational companies and listed entities like Bajaj Holdings, WNS, Tech Mahindra, KPIT Technologies, and Thermax. Welcome, Vallari. Along with her, we have our very own Bala sir and Sudhakar sir, who would be presenting today on the concept of related parties. Over to you, sir.
Vallari, you can share your thoughts on the topic.
Thank you, sir. Thanks, everyone. And at the outset, thanks for giving me this opportunity. And I'm sure this entire series is going to be wonderful, looking at the topic and all the discussions that everyone will be having on the entire subject. I think related party transactions has been in existence for a very long time, primarily in terms of accounting disclosures, but it has gained importance in terms of governance mechanism and the approval mechanism, rather we would say in terms of looking at the nature of transactions, getting into the verification of the transactions. So that's in the recent years. Predominantly, it started for listed entities, but now even Companies Act has introduced related party transactions for all the companies. So that's where not just the listed companies, but even the larger level of other companies also will get covered under the provisions. And they also will have a better governance mechanism overall. I think last couple of years, it's again becoming more and more important. We have seen few instances where there was a governance failure in terms of related party transactions. I think the first one that I can recite is the Satyam matter, where there were related party transactions. However, maybe there was failure of identifying the arm's length, or maybe identifying if there were being done for a valid reason, or as recent as the ICICI Bank and the Vodafone matters, because of which I think a lot of changes have been proposed in the regulations. Now, in the recent era, at least last 2 years, this topic is again becoming a very hot topic, and this needs a combination of understanding the identification of various parties, transactions, putting them up through a governance mechanism, and reporting and disclosure, both in terms of your annual report and stock exchange reporting. There are practical challenges I think we all are facing, but I think this is how, when we discuss, we share our thoughts, we will be able to get better insights and take the right steps as what regulators are expecting. That's all right now from my side. Thank you, sir.
Good morning to all of you. As she puts it, related party transactions are one hot topic. Any number of times we look into the related party, every time we get the new concept and new ideas, new interpretation, which actually comes in. Basically, the related party transaction, what happened, the promoter who actually promote the company, they are there. Really speaking, any promoter who are there, he would not like to hand over the company to the third person totally unknown to him. But whereas we want to have everything to be done in the larger interest of the stakeholders of the company. Gone are the days of the shareholders concept, but it is the stakeholders concept. In view of that, what is happening is there are a lot of conflict of interest. When the related party is there, the treatment of the related party rather than the unrelated party differs, which gives the rise to the various frauds, scams, etc., That is what we have witnessed in the past in the early 2000s. Even Enron was because of that only. Because over a period of time, people become so friendly, they become so related, and things go something about. This is the thing. So with that, the regulators are actually tightening the knobs. And as Vallari puts it, there are various issues, what to disclose, what to not to disclose, how to identify, how to actually determine it is arm's length or not arm's length, how to determine whether it is a normal course of business or not a normal course of business. All the things are very important. Basically, today's topic of Sudhakar, who is a very well-known orator across the country, he is actually going to give us the conceptual concept of the related party. There are various concepts. If you understand the concept well, then our application mind will be definitely better. Because basically, any mistake we do, because we interpret wrongly, the interpretation of the law, that is the thing. So the conceptual understanding and the interpretation of the law is a very most important. Today in our series, we are going to have a conceptual understanding of the related party terms which are associated with us in terms of definition, in terms of Companies Act, in terms of LODR regulation, in terms of accounting standard. That is the whole idea today. I think with these few words, I will hand over the mic to Sudhakar. Mr. Sudhakar, please.
Yeah. Thank you very much, Bala sir. Good morning, all participants. In fact, as Professor Bala is mentioning, and Vallari also, of course, said the same thing as far as related party transactions is concerned. At Mehta Mehta, when we conceived this idea of this webinar series on related party transactions, because of late, wherever I get an invite, whether it is chapter, whether it is regional councils and all, the most sought after topic is related party transactions. In fact, right from 2014 till date, how many programs I have done on this particular topic, I really lost count also. I always say that this topic is like a Nai Naveli Dulhan, evergreen bride, and I can say. At the same point of time, I also say that this is going to be the darling of the regulators, because whenever a regulator, God forbid, comes for an inspection or investigation, the most sought after section for an investigator or inspector is section 188. Despite the fact for the last almost 7-8 years, we are implementing this particular section, but the complexities and the nuances are increasing day by day. They are not getting reduced. As you all aware that at ICSI, we came with a guidance note on related party transactions about 3 years before. And in fact, we had several of the subgroup used to have the meetings that point of time at Mehta Mehta's office only. I still remember those days where Atul Bhai and Dipti used to lavishly give us this arm press so that we can work with more zeal and other things. And after that, about a couple of months before, we have revised the guidance note once again. So when we were working on this guidance note for the first time also, and the second time when we were revising also, the complexities, I thought instead of getting reduced, they have increased it further. So we thought that we are around the closing of the financial year, and I'm sure everyone might be struggling about the related party transactions, and especially in case of listed companies, because of the changes which have come from 1st April 2022. So we thought that let us have an intensified discussion on this particular topic, which we cannot do it in justification in 2 hours time. So we thought, why can't we have about 4 or 5 webinars on this particular a series kind of thing, so that we can spend sufficient time, we can answer all the questions of the participants. The topic, suppose for example, the section, the definition of related party today, which we are discussing for a couple of hours. In the normal course, when I am on the dais, I used to say that, okay, there is a laundry list of the parameters are there on which, based on which the related party is to be determined. That's it. Only with one sentence, the entire section has gone. Never the discussions used to take place, and whether what is the nuances of the section 2 subsection 76, we never discussed that. The objective of this particular series of webinars is that to discuss it in depth of each and everything. Today we are going to discuss about the related party transactions in general and as well as the definition of related party. Next time we will discuss about the related party transactions. After that, there is some key terminology is there, which is very, very important when we are ensuring the compliances of related parties, like your ordinary course of business. What is ordinary course of business? What is arm's length? And similar, there are several things like what is office of place of profit? What is the term of a goods? There are several things like that. At the same point of time, we can also see the approval mechanism. After that, we have to see the disclosures and reportings and other things. So like that, maybe we can have 4 or 5 webinar series. So with this small brief, let me start my presentation. And as usual, we can, wherever we feel like we can have our discussions about that. So today, as I have mentioned, that we are going to look into only 2 things. Number one, understanding of related party transactions, and the second one is who is a related party. So one of the most important elements of corporate governance of any organization is that how the related party transactions are handled. Several corporates might have received the corporate governance awards from any institution. That is not the important, but if I have to rank a particular corporate for its corporate governance, the fundamental thing what one has to say is how that corporate is handling the related party transactions, apart from, of course, from other parameters also. But this is the key concept, how that corporate governance structure is established, that depends upon how the policy on related party transactions is drafted and implemented. Whenever or wherever there is a transaction with a related party, as we all are aware, there is a scope to give a benefit or undue advantage, and the same is presumed to be given unless until it is established otherwise. Though per se, RPTs are not disadvantageous to the organizations, or per se they are not bad, they need not be banned or prohibited. But considering the scope to give a benefit or undue advantage to the related parties, unless until that it is established or the framework, whatever has been devised by the regulators, it is compliant to the core. Similarly, mere compliance is also not sufficient, but that is to be established at the end of the day. That's why right from the beginning, I used to say that as far as related party transactions are concerned, by mere compliances is not sufficient. Tomorrow, when the inspection takes place, you should be able to establish also, yes, that we have ensured the compliances, and and you have to establish that how you have ensured those compliances. The transparency in case of related party transactions is not only essential, but also very crucial, because the law requires certain specific compliances with respect to related party transactions. Another important thing is, if you see the guidance note, also the statement is there that every transaction with a related party may not be a related party transaction, but every related party transaction is necessarily a transaction with a related party. This particular line, what we have coined when we were drafting the guidance note, you will find this only in the guidance note, not in the law as such. When we were drafting the guidance note, we thought that let us demarcate the compliances what are required under 188 and compliances what are required under 177. To demarcate these transactions with a clarity, we have just called that whatever the section 188 subsection 1 A to F, those transactions we may call it as related party transactions. So that's why we can say that every transaction with a related party may not be a related party transaction, means every transaction with related party might not have been covered under section 188 and the compliances thereof are not required. But every related party transaction is necessarily a transaction with a related party, means the transactions which are not covered under 188, but still if there is a transaction with if there is still a transaction with the related party, those may be covered under 177. The transactions what requires 188 approvals, that is board as well as the shareholders, wherever the threshold limits are triggered, those are only 6 to 7 type of transactions, whereas all other transactions that definitely certainly requires audit committee approval. There is a general presumption that the transactions reflected in the financial statements, that means whenever a shareholder receives the balance sheet or profit and loss account, the general presumption is that all these transactions are consummated on an arm's length basis between independent parties. However, this presumption may not be valid when there is a related party relationship exists. To understand the legal fabric of RPT, one has to look into the provisions of Companies Act as well as the listing regulations, and of course, as far as the disclosure purposes are concerned, accounting standards also. So considering the sensitivity connected with the related party transactions and to develop the legal fabric, both Companies Act and listing regulations have stipulated various stringent and according to me complex compliances as well as disclosures also. So in order to appreciate the nuances of the compliance mechanism as far as the related party transactions are concerned, how we have to start, where we have to start. First and foremost thing is we have to see that the company, when it is entering into a transaction with any other party, whether that party is my related party or not. So whether my related party means that relationship, and we have to see that, obviously, if it is an unlisted company, we have to simply see that section 2, subsection 76. And if it is a listed company, beyond that, we have to also see the definition given under the listing regulations, that is rule 21ZB, as well as of the accounting standards. Once we are sure that yes, the transaction with whom we are entering into, that is my related party, once it is determined, then the second test is that whether the transaction with being entered into with that related party is a related party transaction. Means that whether it is covered under 188 and at the same point of time, whether it is covered under rule 21ZC, regulation 21ZC. Then obviously the mechanism as far as the related party transactions are there, you have to requisite approvals are to be taken. That is audit committee, board and shareholders as and where they apply to. The third thing is that whether this transaction being entered into is in the ordinary course of business and at arm's length. If it is so, further that as far as the compliances are concerned, to a large extent, they are reduced because section 188 is completely exempted. But in case of a listed company, such exemption is not available because under the listing regulations, no such exemption is there. So compliances as far as the listing regulations are concerned, they have to be continued. But Companies Act, whatever the compliances are there, even to that listed company also, 188 compliances may not be required if it is in the ordinary course of business and at arm's length. Finally, whether the transaction, which is being entered into, when it requires the audit committee approval, whether it qualifies to get that approval on omnibus basis or specific approvals are required. So this is how we have to see that before structuring the compliance mechanism as far as the related party transactions are concerned. At the same point of time, we have to also understand there are two duties of directors which have been prescribed under section 166, that a director of a company shall not involve in a situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. So it is the director has to be very sure that whatever the given situation, especially when a transaction is being entered into with a related party, he should ensure that he has no conflict of interest and he is not connected to that other related party is concerned. So the director also has to ensure that he shall not achieve or attempt to achieve any kind of undue gain or advantage, either to himself or to his relatives, etc. And hence it is very important for the directors, they should exercise due diligence and they have to be vigilant as well as diligent enough before approving any related party transactions. And they have to satisfy themselves that the proposed transaction is not hampering the interest of the company or of its stakeholders because of any of his remote connection with that related party. Because any kind of non-compliances, it may lead to his disqualification of acting as a director of the company. So the directors should be very, very careful about this particular thing. And it is also the responsibility of the company secretaries to sensitize the directors. Sometimes unconsciously or consciously, they might not be giving the amount of importance as far as the disclosures are concerned. So it is the responsibility of the company secretary to time and again sensitize the directors, and especially when they're considering the related party transactions, whether any kind of disclosures they would like to give. So the applicable provisions, as we all know, that Companies Act 2013 and listing regulations wherever it is required, and of course accounting standards. Now let us see the definition of related party under the Companies Act 2013. If you see, the section starts like related party means, with reference to any company means. Hence, this definition is a very exhaustive definition. It is not an inclusive definition. And if you see, there are almost, to my knowledge, about 32 parameters are there which determines the definition of a related party. So it is always advisable to prepare a matrix, and we have to ensure that in that matrix, there should not be any tick mark anywhere. The moment there is a tick mark, it means he is a related party. So one has to be very careful about while examining and coming to the conclusion of the parameters. Second thing, always I have been asked a question is that whose responsibility is to identify who is a related party? Is it the responsibility of the board, or is it the responsibility of the audit committee? Is it the responsibility of the CFO or company secretary, or finance and accounts department, or secretarial department? No doubt about it, and the ultimate responsibility, of course, is of the board. But most of the times, related party transactions are to be approved by the audit committee. So it is one such committee to which all these responsibilities have been delegated by the board. So audit committee has to ensure that the identification or the determination of related party is as per the law. So now question comes, is it the accounts department or the secretarial department who has to identify that? It is always the responsibility of the secretarial department only, because they are the custodians of the information, the disclosures given by the directors. If you see the section 2, subsection 76, or even rule 21ZB, to determine a related party relationship, the entire information, whatever is required, it is available with the company secretary to a large extent. That's why it is the company secretary who has to identify who are the related parties and has to give it to the accounts colleagues and to inform them that in case any transaction takes place with these related parties, you please escalate it to us and we will ensure the necessary compliances. So now let us go one by one. What is this section 2, subsection 76 says? The related party with reference to a company means, as I told you, it is an exhaustive definition, a director or his relative. Director is already defined under the Companies Act, and coincidentally, it so also happens the relative is also defined under the Companies Act. So there is no kind of any what's called there is no scope of interpretation, because the relative also we have to see that section 2, subsection 77. Whatever the relationships have been given there, only those are the relatives, and not the all other relationships are not falling under the relative definition. Then a key managerial person or his relative, a firm in which a director, manager, or his relative is a partner. Here, in fact, there was initially there was a confusion, and some people used to interpret that because of the comma which is there after the director. A firm in which a director, comma, manager or his relative is a partner. So some people used to interpret that relative is with respect to the manager and not with respect to the director, because of the comma is there. And if you see the next sentence, a private company in which a director or manager or his relative is a member or director. So no comma is there in between. So some people used to interpret at that point of time, this relative in case of a firm is applicable to the manager, but not to the director, which was not correct, of course, interpretation. Subsequently, I don't know, but in general, everyone has agreed to that. A firm in which a director or his relative is a partner, or manager or his relative is a partner, is a related party. Then a private company in which a director or manager or his relative means, again the same thing. Here, or his relative is applicable both to the director as well as to the manager. And if they are members or director in the private company, question comes whether if they are member or a director, then there is a related party. that private company. So that means what? Suppose if I am having my company, there are 5 directors are there. All the 5 need not be the director or members of the private company. Even if one director is a director or even one director of my company, the company to which you are examining the related parties, if any one director is a director of a private company or a member of that private company, then that private company will become a related party to you. Similarly, when we talk about the membership, when he becomes a member, even a single share if he is holding in that private company, even then that private company becomes a related party to this company. Then a public company in which a director or manager who is a director and holds along with the relatives more than 2% of its paid up share capital. That means, suppose in case of a public company, how it happens that if a director or his relative holds more than 2% of its paid up share capital. That means what? Suppose he need not be a director of that other company, but if he is holding more than 2%, say for example, in a public company, my wife is holding more than 2% of shareholding. I am not having any shares, but still that other company will become a related party to my company. Any body corporate whose board of directors, managing director or manager is accustomed to act in accordance with the advice, directions or instructions of a director or a manager. That means if my board, my MD or my manager is accustomed to act as per the instructions of the other company director or manager, but of course it is not a professional capacity, then in such case, they become the related party. Similarly, any person on whose advice, directions or instructions a director or manager is accustomed to act. Suppose that means what? Suppose if that means in fact, if you know that Sahara case, Subrata Rai Sahara has mentioned that 2 cases that where they have mobilized the funds and without filing any document with the SEBI and all those things. When that went to Supreme Court, he pleaded that he is not a director of that company. He is not even a member of that company. He is not even a shareholder of the company. He is not a promoter. He has nothing to do with those companies. That's what he has pleaded there. But that point of time, of course, Supreme Court has said that they are just accustomed to act, that 2 companies are accustomed to act as per instructions. That means what? Virtually, if you lift the corporate wheel, the person behind the show is that particular person. So like that cases are there, then also they become related party. Now, when this question of accustomed to act, how to ensure that accustomed to act? Is it one-off transaction is there? Can I say that I am accustomed to act? Especially this particular thing was there initially under section 185 also, the erstwhile 295, that 185 1E, it says that if you remember in the Companies Act 2013 when it was legislated, 185 1E were virtually prohibited, all those transactions. Subsequently, under the Companies Amendment Act 2017, 185 1CDE were permitted with the approval of the shareholders by way of a special resolution. But initially, it was virtually prohibited. All that the A to E transactions were prohibited. So because of that, what happens was that the wholly owned subsidiary companies and the subsidiary companies, it was a presumption that they are accustomed to act as per the instructions of the parent company, and that giving loans or giving any guarantees to them is prohibited. So the banks were hesitant in giving loans to the subsidiaries or wholly owned subsidiary companies based on the corporate guarantees given by the holding company. So that point of time, we used to, several of us have taken a decision that, we've taken an interpretation that not necessarily a wholly owned subsidiary company or a subsidiary company are accustomed to act as per the instructions of the holding company, because every company has its own corporate personality, has its own board of directors. Whatever the holding company is asking the subsidiaries or wholly owned subsidiaries to do, they may be taking the instructions into account, but they might not be blindly complying with that. So anyway, that in fact, several legal opinions used to be taken by the people to go to the bankers and all get the loan sanctioned. But subsequently, after a couple of years, those issues have been addressed to, and that Companies Amendment Act 2017 has relaxed in those provisions. So here in this case, when we are saying that accustomed to act as per the instructions, there should be instances or documents indicating advice, directions, or instructions by a director or manager of a company to the board, managing director, or manager of the body corporate. That means if any other company is having a relationship to my company, that is, if I am coming under this thing that this particular manager, this company's managing director or manager is accustomed to act as per the instructions of other companies' directors or managing director, whoever it is, then there should be some kind of a documentary evidence. And based on that only, you can say that you are accustomed to act. So that means what? By mere presumption that you are accustomed to act will not be stand to scrutiny. Such advice, directions, or instructions are to be other than in a professional capacity. That means if somebody is giving you the advices in a professional capacity and you are accustomed to act as per that, that doesn't mean that other party will become a related party to the company. So similarly, the board, manager, or directors of the body corporate act in accordance with such advice or directions or instructions. That means what? Mere giving the instructions or advice is not sufficient. This company or its board or its directors, they have to act as per the instructions given by merely showing the mails that somebody is asking you to this company's board to do something, but never this board indulges in doing or complying with those instructions. Then also you cannot say it is acting as per the instructions. Hence, it is to be established that there have been series of events where they are accustomed to act. That means there should be instructions to the company to act in a particular way, and the company has obliged and acted in such according to those instructions. And a single or isolated event or two would not be sufficient. So there must
somebody has put a question here.
Yes.
In the 6th point, is it whether the director, manager of the other body corporate is accustomed to act under instruction of our company director, or our company director is accustomed to act according to the instructions of the other?
Say, I will clarify that. Say, for example, my company is A Limited. I am determining the related parties to my company. If my company's managing director or a directors, executive directors, I meant to say, or the board as such, if they are accustomed to act as per the instructions given by some other company's board or other company's managing director, then that company will become a related party to me, not vice versa. Similarly, if there is an individual, suppose Professor Bala is giving instructions on my company is A Limited, Professor Bala is giving instructions to me to do a particular thing in a particular way, but not in a professional capacity. And I am complying with those instructions for whatever the reasons it is. And you have no connection with my company, but still you are giving instructions to me, and I am as a director or as a managing director, I am complying with your instructions. You are my related party. Any other question?
You rightly said.
Yeah, Vallari.
No, sir. You rightly said there are two sub-clauses, and one refers to the body corporate, which is accustomed to act based on the instructions or directions, and the other is the person on whose advice, instructions, the director or manager is accustomed to act. So this way, the interpretation or the example that you gave is exactly clarifying as to who will be considered as a related party, because the determination is based on the reporting entity, the entity for which the related party has to be determined. So that example was absolutely correct.
Yeah. Can I go ahead, Professor Bala?
Yeah. In fact,
Okay.
one more thing I was asking on the body corporate.
Yes.
Sir, body corporate include only foreign company or all company under section 276? With the word company replaced with the body corporate, kindly clarify.
That when it comes, we will discuss that, because
Sure.
it is still, let it come first and then we will discuss.
Sure.
So now exactly we are actually touching that particular sentence only, that if you see that in the beginning of the when this Companies Act 2013 were notified, the word used was any company which is holding subsidiary or an associate company of such company, or a subsidiary of a holding company to which it is also a subsidiary. Like that it was there. So because the word used was any company, with this what happened was, if any body corporate, that means a company incorporated overseas, if it is my holding company, or if it is my subsidiary company, or if it is my associate company, that company was not related party to me. The reason being the word used was company. Company means any company incorporated with the Companies Act. In case of a company which was incorporated overseas, because of this particular terminology which was used, initially there was a confusion. And of course, no doubt about it, if you rightly interpret it, it is so also that those companies have not related party transactions under the Companies Act 2013. That was a lacuna, of course, for about, in fact, okay, that I used to tell people enjoy till the time the regulator is not noticing this. Of course, regulator has noticed that, and in Companies Amendment Act 2017, the word company has been replaced with the word body corporate. But one thing is there, even at that point of time also, if you see the definition of subsidiary company, there it says that when you are taking a subsidiary company, even a body corporate is also a subsidiary, which was not the case initially with the holding company. But subsequently, holding company's definition is also amended, and now even a body corporate is also a holding company. Then comes, there was another lacuna was there earlier, that my associate company is my related party, but I am not related party to my associate company. Means what? Say, for example, Reliance Industries has invested 20% plus in A Limited's paid up capital. Because it is investment of 20% plus, A Limited is associate to Reliance Industries Limited, but RIL is not related party to the A Limited. So when I am determining the related party for RIL, A Limited is my related party. But when I am determining related party for A Limited, RIL is not A Limited's related party. That means it was a one-way relationship was there. Subsequently, this has also been taken care again in Companies Amendment Act 2017, wherein they said that an investing company or the venturer of the company is a related party. Then they have clarified also that the investing company or venturer company means a body corporate whose investment in the company would result the company becoming an associate company of that body corporate. Means what? If RIL is invested in A Limited 20% plus capital, because of by virtue of that investment, if A Limited has become associate company to RIL, because as defined associate company was defined under section 2, subsection I think 6, if I am not wrong, it says that any investment of more than 20%, that other company becomes associate company of mine. And what it says is, because of my investment in that other company, it becomes an associate. The investing company, that means RIL, will also become a related party to the other company, that is to A Limited. So now the two-way relationship is established. But this subsection is not applicable in case of a private company, because that in the notice, in the notification dated 5th June 2015, wherein some privileges have been restored as far as private companies are concerned. This was also one of the things and which was exempted. So a director, if you see that, it also says that any other things as may be prescribed, and in the rules, another thing, only one thing till date has been added further was a director other than an independent director or KMP of the holding company or his relative. That means a director or his relative, but director, if an independent director is there, they're excluded. And the KMP of the holding company is my related party. Okay, but this means what? The directors or KMP of a subsidiary company or associate company or their relatives, they are not my related parties. This is also another, I mean, okay, as on date, you can say this is a kind of a lacuna or whatever we may call it as. When my holding company's director is a related party, why not my subsidiary companies? But only the logic come to my mind is holding companies directors may be in a advantageous position of able to control the subsidiary company, whereas the subsidiary company or associate companies are not in a position to say anything to that holding company. That might be the reason they are not covering the directors of the KMPs of subsidiaries. But according to me, as a good governance,
because,
Vallari, your views. Yeah.
Just 1 minute, let me complete my views.
right.
Might be as a
Yes,
good governance measure, they would have covered even the directors or KMPs of subsidiaries or associate companies also in the related party definition. Might be they might have kept this controlling aspect in their mind and they have not covered it. Yes, Vallari.
Right, sir. I think I was also saying the same thing, that it is predominantly with the thought that it's the undue advantage which can be gained because of the position of power, and which could come with the holding company and presume that it is not with the subsidiary or an associate. And that's where this would have been the logic. You just clarified that, right?
Correct. Any questions, Bala, till now?
A couple of questions are there, but I think probably something related to the transaction, which we won't take it. Because
that we will take it later and while concluding we can do that.
Yeah, correct.
Sir, just one thought on the public limited company. I think it is in case of a public limited company, the director also has to be a director and holding the 2% capital with the relatives, right?
If I am not wrong, it is not so, because if it says that a public company in which a director or a manager, sorry, who is a director? He should be a director and holding 2%. Correct.
Because I think, sir,
correct. I agree with you, Vallari. Sorry.
Yes, Vallari, your view is absolutely correct. It should be 2%, the director, because the wording is here. Yeah.
Right, sir. And I think the first draft in 2013, they had said, I mean, not holding more than 2%. It was giving a lot of discomfort to the directors, because they could have been holding more capital in other public limited companies, and simply because of shareholding, the entities could not have been considered where the directors could have had their control exercise. So maybe this was then later on modified, but that was something relevant at that point of time to check.
Yeah, the only thing is that that particular director, even if he is not holding any shares, but his relatives are holding, still it is a related party.
Yes, absolutely. So director is a director. He may not be holding a shares, but then his relatives are holding, and then all put together 2%. So absolutely, that entity becomes a related party.
Deliberately,
but again, there also, Vallari, if you see the beauty is that this company is not a related party to that company. That company is a related party to this company, but this company is not a related party to that company.
Right. And again, the logic would have been that this director may be in a position to gain undue advantage on behalf of the other company where he's holding more than 2%, and that's where he may have a personal interest or a conflict of interest presumed to.
Deliberately, I want to hold only 1.9%, not 2%. Because
Balasa, that in fact, if with 2%, if you can control the company, what can I say that? Who can control with 2% shareholding? You know, even if in RIL also, suppose a company like Reliance Industries Limited, we can't even think of holding 0.2%. Forget about 2%. But even if you are holding 2% shareholding of RIL, can you do anything? You can't, you know, because what's called that numerical is very, very important. With 2% holding, whatever the size of the company, they can't do anything. But anyway, better that it is the law as on date that with the 2%, if it is there, that company becomes a related party. And I couldn't find at least any logic. And though other you are saying that, yes, no doubt about it, that company may influence and all those things. With 2% shareholding, how much I can influence, except that a sentimental or emotion relationship I may have it. And by director who may 2% shareholding. And maybe in the 184, that 2% concept is there, if you remember.
Correct.
Okay, that conflict of interest or something like that. Because of that, they may say that related party. There, that no doubt about it. The 2%, the earlier it was there, all the directors together, if they're holding more than 2% of the other company. That might be the only reason.
That's where the 2% logic would have come. Absolutely agreed. But validly said, sir, I think it is immaterial about the shareholding. If a director has to influence, it can be influenced even only with the directorship. It need not be with a single share being held. So, which is quite possible. But anyways, as you said, this is the law of as on date. So we have to abide by it.
Correct.
Right.
One more thing is there. And for a public company, or both conditions should be fulfilled, as it says, director or manager and holds along with the relative more than 2% of the paid up capital. That is the question, if I understand correctly, whether he himself 2% or along with the director relative 2%.
No, see, whether if a director, he himself or together with his relatives holding more than 2%. Even if he is not holding, his relatives are holding, that is sufficient. Suppose he is holding 1% and his wife is holding 1%, even then it is a related party. So total together should be more than 2%. And there the relative definition, definitely I am repeatedly saying that we have to confine to the relationships as per the section 2, subsection 77 only.
Yeah, you're right.
Yeah. Can we go ahead?
Yeah, please.
Okay. Now, we have seen that section 2 or 76 under the Companies Act, as I was mentioning, this is only for the unlisted companies. Now, if your company is a listed company and over and above that, you have to also see the Rule 21ZB of the listing regulations, which has defined the related party. And before we go further, let me also inform you that SEBI has constituted a working group in the year November 2019 to review the policy space pertaining to the related party transactions under the chairmanship of Mr. Ramesh Srinivasan, who is the Managing Director and CEO of Kotak Mahindra Capital Company Limited. The working group has submitted its report in January 2020, and the major changes which have come, which have been, which are effective into force from 1st April 2022, as well as 1st April 2023, they're all germinated out of this particular working group's recommendations only. So the definition of the related party under 21ZB was, is the entity shall be considered as a related party if such entity is a related party as defined under section 276 of the Companies Act 2013, or such entity is a related party under the applicable accounting standard, that is AS 18 or Ind AS 24. Because of this, if you see the definition of AS 18 and Ind AS 24, that the definition is more wider, and together, because as far as the listing regulations are concerned, either it is covered under 276 or it is covered under the accounting standards. It is not and covered. So because of that, what happens is, if your company is a listed company, the definition of related party is much broader. Sometimes I used to say that, in fact, instead of identifying who is my related party, it's better to identify who is not my related party, because very few people may be there. Otherwise, most of the times it happens that virtually everyone connected with, the company, to a large extent, they're all getting covered. Because if you see the related party transaction in face of the listing regulations, it is, much, much broader than what it is under 188. That when we will discuss it, we will discuss that. And very surprisingly, that till 2019, the promoter as such was not clearly identified as a related party. Of course, no doubt about it, if the promoter is controlling the company or significantly influencing the company under the accounting standards, in case of a listed company, no doubt about it, it is indirectly covered. But the promoter as such was not covered under the related party definition in the listing regulations. Same is the case with section 276 under the Companies Act also. Promoter is not covered there. So there also maybe promoter, if at all it is to be covered, with if the promoter is giving instructions and the board or the managing director is accustomed to act as per the instructions of the promoter, maybe there the promoter is a related party, otherwise not. But the listing regulations were amended, which were notified from, which were implemented, came to force from April 1st, 2019. It says that any person or entity belonging to the promoter or promoter group of the listed entity and holding 20% or more of the shareholding in the listed entity shall be deemed to be a related party. This amendment was not very effective according to me, because they have used the word, they have not said any persons or entity belonging to the group. So here what it says, any person or entity, it is not persons or entities belonging to the promoter or promoter group. Because of that, what happens is, even if in the promoter group, there are 10, 20, 30, whatever the entities are there, persons are there, if they hold 20% or more, then only that particular person or that particular entity will become a related party, but not the entire group as such. So if you see the shareholding pattern of the companies, I don't think anyone is holding 20% plus shareholding in one person or one entity. Mostly it happened that the promoter or promoter group, the people collectively might be holding 20% plus, but not at the individual level. The working group was of the view that all the persons or entities belonging to the promoter or promoter group, irrespective of their shareholding, should be deemed to be related parties because they are in a position to exercise significant influence or control. Whether they are holding the shareholding, whether they are holding shares or not, still they may be able to control indirectly or may be able to influence significantly. So the working group has suggested that the shareholding of the promoter for to determine him as a related party should not be the criteria. Then this was accepted now. So from 1/4/2022 onwards, any person or entity forming a part of the promoter or promoter group of the listed entity means what? If any person or entity, even if they are holding 0 shares also, because if you see the shareholding pattern of the listed companies, you will find certainly there are entities or persons whose names are there in the promoter or promoter group holding 0 shares. One of the reasons for that is whenever in future interstate transfers takes place among the promoters or promoter group, that if they are holding the shares for the last 3 years, if they're part of the promoter group, then they are qualified for the interstate transfers and no public offer gets triggered. For that purpose, some companies that do give the names of the promoters, individuals or entities with 0 shareholding also, even then that companies or that promoter, that individuals becomes related parties. The working group also has said that promoters may exercise control of promoter group entities and consequently influence decision making of the group as a whole. Sorry, this is okay. The second thing what the working group also has suggested is, sometimes it may so happen the people might be holding 20% or entities might be holding 20% plus, but they may not be promoters or but they are certainly major shareholders. And they may be able to influence the company or they may be able to exercise control over the company, despite the fact that they are not wearing the hat as a promoter or as a founder or whatever the case may be. So in such case also, those people are to be covered under the definition of promoter. So this particular recommendation has also been accepted. And now the definition of related party under 21ZB is that any person or entity holding equity shares of 20% or more or of 10% or more with effect from April 1st, 2023. So in a week's time now, till 31st March, you have to see that 20% criteria, 20% or more shareholding. And from 1st April 2023 onwards, that has been reduced to 10%. And another important thing, what I would like to draw the attention of the participants is that this 20% and 10% is not in the financial year, but it is of the previous financial years. At the same point of time, even if that shareholding is on a beneficial interest basis, where that means under your section 89, even then also it gets covered under the related party definition. That means any person or entity holding equity shares of 20% or more or 10% or more with effect from April 1st, 2023 in the listed entity, either directly or on a beneficial interest basis, as provided under Section 89 of the Companies Act 2013, at any time during the immediate preceding financial year. This is a very, very important thing what one have to understand. Now, let me explain this further, giving examples. Say, for example, I am holding say 9% shareholding of a company effective 1st April 2023, I am holding 9% shareholding in my direct name, and another 2% I am holding the shares. Though I am the registered owner, I am not the beneficial owner. And I have given the necessary declarations under section 89 that I am the registered owner, but not the beneficial owner. That point of time also, if I am the beneficial owner, but not the registered owner, then it will be clubbed together with my direct holding, and that 10% is to be arrived at. Another important thing is, as I was mentioning, at any time during the financial year, means what? Even if for a single day, strictly speaking, even for a single day, if that 20%, 10% holding is there, that is also to be counted. And as per the preceding financial year, now let us see that we are in the financial year 22-23. That means I have to see my register of members of the previous financial year, that is 21-22. Who are the people holding 20% plus share? Is there any person or any entity? Here also, please remember that it is not a group of persons or group of entities. It is only the individual person or individual entity holding more than 20% shares in the previous financial year, that is 21-22. Even if they are not holding any shares in the current financial year, that is 22-23, even if they are holding zero shareholding, but still they are my related parties as far as the financial year 22-23 is concerned. That means Mr. A is holding 20% plus shareholding in the financial year 21-22. And if my company is entering into a transaction with Mr. A during the financial year 22-23, it is a related party. It is a transaction with a related party. Again, if that Mr. A is not holding any holding in the financial year 22-23, irrespective of that, he is my related party for the financial year 22-23. But if this gentleman is not holding any shares in the financial year 22-23, for the financial year 23-24, he will not be my related party. That means based on his shareholding in the previous financial year, he is becoming for the related party in the current financial year. And if he is not holding any shares in the current financial year, he will not be my related party for the next financial year. That means once a related party, always is not a related party. That is also equally important. And similarly, if this the 10% clause is coming into force from 1st April 2023, that means any entity or a person who is holding 20% plus in the financial year 22-23 or related parties for the financial year 23-24. Am I clear? And at the same point of time, from financial year 23-24, whoever is holding 10% plus holding, they will be related parties for the financial year 24-25 onwards. So one has to be very clear as far as this shareholding is concerned, because it is based on the previous financial year, not based on the current financial year. Please be, slightly careful while you are determining the related parties in case of listed companies.
So that means here the interpretation is very, very important. Even in the current financial year, if we are not holding anything, but doesn't matter, but what has happened in the last financial year, if the answer is yes, you continue to be a related party in the current financial year.
Correct.
Sir, I have a few questions there. I think the shareholding, which you clarified, is 20%, 10% at any time during the preceding financial year. But one question that comes up is it going to be only a single folio that will have to be looked at? Because when you report the shareholding pattern, it's always a clubbing basis, the PAN. So there could be multiple folios under the same PAN, and with that clubbing, it could probably cross the threshold of 10% or 20%. So how should we look at this?
See, Vallari, as per the law, in fact, if I'm not wrong, as per the listing regulations only, if this hold, I think under the Companies Act also, multiple folios are not to be there. Okay, a person can never make applications in the IPO also, more than one application. So multiple folios should not be there. If at all, by any reason, if anybody is having multiple folios at one point of time, if I am not wrong, an option was given to consolidate all of them into one folio, right? So here what the word they have used is any person or entity. So you don't need to club all that, that PAN numbers of that. Suppose if a person is having multiple folios even till date and he has not consolidated it, no doubt about it, identification of that person is PAN number only. Right? That means to arrive at 10% plus or 20% plus, no doubt about it, you have to run through your ROM based on the PAN. If it is throwing that for that particular PAN, which is unique, if anybody is holding 10% or 20% plus, he is or that entity is your related party.
Right. Because it may so happen usually less probability with FIIs, but still 10% could be a threshold that some of these FIIs, mutual funds may collectively
Correct,
cross.
absolutely.
There are
yes. Even high net worth individuals, say for example, LIC, most of the times LIC is holding more than 10% in several companies.
Right. Absolutely.
I don't know now at present, but at one point of time, LIC was having 12% plus in RIL itself. Okay. So definitely, as you rightly said, FIs and FIIs, they are having this thing. And sometimes even the, what's called as this HNIs, high net worth individuals, they are also holding it, in small listed companies and all. I'm sure they must be having 10% or 20% plus. But only thing what we have to ensure is that, suppose if I am holding in a listed company together with my family members or with my HUF and all, collectively 20% or 10%, that collectively is not to be taken. Individually only is to be taken.
Right. Absolutely, sir. I think then PAN is a good identifier to ensure that it's just the same person or entity which is holding that much of shareholding. Also, a practical challenge again, while the language says at any point during the financial year, we will only have access to the shareholding as on the Friday benpos or the Friday data that we get. So while we will say we are compliant, this also is small gap where we will be identifying a related party only basis the information that's available. So I guess even that's probably understood and settled with
even I presume it just for this particular purpose, you don't need to have the benpos on a daily basis, which is going to cost the nose completely. And whatever the benpos download is there on Fridays, this thing, based on that only we have to arrive at this.
Right. Absolutely.
Or by any chance, there is one more thing also, Vallari, I cannot simply wash off my hands also. Sometimes the block deals take place. And you have to be vigilant whenever the block deals take place. Yeah. So you have to keep a track of the block deals also. If any block deal takes place, then yes, you have to keep that. If it is more than 20% or 10%, even for a single day, the block deal is there, then he will become a related party.
True. Absolutely, sir. Yes. That's it. Thank you.
Though it is not very simple, but this is what the law is, and one has to be very careful, and especially in case of listed companies who are getting regulated by SEBI. And SEBI, with all due regards to MCA also, of course, no, I don't say that MCA is not sensitive enough, but SEBI is very sensitive enough. At the same point of time, the listed companies are radar of the proxy advisory firms. So sometimes even if the regulator may be making a fox pass, but the proxy advisory firms may be there who are keeping a track of your transactions. And the proxy advisory firms are very sensitive and emotional as far as RPTs are concerned.
Right, sir.
Okay.
Yeah.
Bala sir, any more questions? There are certain things which are there, but I don't know. Let us see. Let us go through one by one. I'll go from down. That will be better.
Okay. Now, in the meantime, let me proceed further. Then we can discuss the questions afterwards. Otherwise, we can also even ask the participants to open.
Okay, no problem. We'll take the questions. You finish it off, then we'll take the questions.
Yeah. So, because we are in the verge of, again, the closure of the financial year, I thought, let me also identify some action points as far as the RPTs are concerned. Sorry, RPs are concerned, determining the related parties are concerned. No doubt about it, the particular in case of, see, as far as the unlisted companies, the Companies Act definition, there is absolutely no change in the financial year 22-23, so they don't need to worry. Only the change what has come in the definition of related parties is only in case of the listing regulations. That also the amendment came into force from 1st April 2022. That's why by now I am sure all the companies would have initiated the action on the points what I am going to discuss. But God forbids if anything is left out also, or anything is newly emerging during this particular 1 week time from now to the closure of the financial year. This may be slightly of help. So one has to identify afresh all the related parties and revise the list of parties. Normally what happens is at any point of time, we used to have a list of the related parties, and this related parties list is to be periodically reviewed from time to time for any kind of additions or deletions of there. Deletions means what? Say, for example, whenever a director ceases to be a director of the company, or a KMP ceases to be a KMP of the company, or whenever the directors who are there as a director of the private company, as a member in the private company, whenever the kind of relationships are ceasing to be effective at that point of time, the relationships get changed. And the concerned directors have to inform the company that, look, I am no more a director of this particular company, of the private limited company, or I have sold my shareholding of the particular company, so I am no more a member. So that private company will not become a related party, that cease to be a related party. So from time to time, one has to review and update the list of related parties. So in this case, what happens is effective 1st April 2022 onwards, you have to include all the persons or entities belonging to the promoter or promoter group. So it is not very difficult to identify who are the promoters and promoter group, because anyway you are filing the shareholding pattern on quarterly basis, wherein there is, you are identifying the holding of the promoter and promoter group, and you are also furnishing the list of the entities or individuals who are a part of that. So all those names you have to add it to the list of related parties if they are not already there. Second thing also is that you have to identify all the shareholders. That means persons or entities who are holding 20% or more shareholding in the previous financial year, that is 21-22. And at any point of time also, as we have discussed just now, that you may, for this particular purpose, you don't need to have to download the BenPOS on daily basis, but whatever the BenPOS is available to you, based on that, you have to come to the conclusion that who is my related party. At the same point of time, whenever there is any block deals are taking place in your shares, then you have to keep a track of that, and you have to also determine the related parties accordingly and update your list. So of course, no doubt about it, this block deals and all, you cannot do it in for the 21-22. Maybe even there also you may review along with your ROM, you may have to review any block deals have taken place during that particular financial year. If it is so, maybe that they may become related parties to you for FY 22-23. Now, for the next financial year, you have to identify, as I have mentioned to you, anybody holding 10% plus from, I mean, that is for the financial year 24-25. You have to see that anybody holding 10% plus during this financial year. Even now for the coming financial year, that is 23-24 financial year, you have to again from 1st April 2023, you have to be ready with your list of related parties. So anyone holding more than 20% plus any person or entity during this financial year, that is 22-23, they will become related parties to you for the financial year 23-24 also. So you have to update the list of related parties accordingly. And you have to also monitor the shareholding pattern at regular intervals to determine whether any person or entity satisfies the thresholds. Now let us see this is so far what we have done is we have seen the related party definition under the Companies Act. We have seen the related party definition under the listing regulations. And now let us see the definition of related parties under the AS 18 and Ind AS 24. This, as far as the unlisted companies are concerned, even they also are concerned with this accounting standard definition of related parties. only for the purpose of disclosures of those transactions in the balance sheet, not for any compliances as far as the company's act are concerned. That means if any related party which is not there under section 2 subsection 76, but they are related parties under Ind AS 24 or AS 18, you don't need to go for compliances of that, but you have to give the disclosures. There is a difference between compliances and disclosures. Certain related parties, if any transactions are entered into, then you have to ensure the compliances. And the related parties only for the purpose of accounting standards, you have to go for disclosures. But in case of listed companies, the related parties which are as per accounting standards also are related parties to the listed entities because of the definition under Rule 21ZB. So under AS 18, of course, this is not, I don't think this is applicable for the listed companies. Parties are considered to be related if at any time during the reporting period. Under AS 18, the definition of a related party is at any time during the period, one party has the ability to control the other party, or one party exercise significant influence over the other party in making financial or operating decisions. That means when you are determining related parties for your company, and your company has ability to control the other party, it may be an individual, maybe an entity, maybe a private company, public company, whatever it is, if you have the ability to control, whether you are controlling it or not also may not be that important. If you are having the ability to control itself, that other party becomes your related party. And same is the case, one party exercise significant influence. Here, you have to exercise that, but by merely having the ability to exercise significant influence over the other party is not sufficient. You should exercise significant influence, then only the other party will become your related party. And what is a significant influence? That is participation in the financial and or operating policy decisions of an enterprise, but not control of those policies. So what is a control? Control means ownership directly or indirectly of more than one half of the voting power. Please see that it is not the share capital, it is the voting power of an enterprise. Then control of the composition of the board, even if you are not having the control of voting, so voting power is not there, but you have the ability to control the composition of the board of directors in case of a company, or of the composition of the corresponding governing body in case of any other enterprise. That means if it is not a company, but say a body corporate, but if you are able to compose, have the ability to control the composition of the governing body, then also it is your related party. A substantial interest in voting power and the power to direct by statute or agreement the financial and operating policies of the enterprise. So this is the definition of the control. So if you have the ability to control the other party, that means you have the ability of voting power, whether you exercise the voting power or not, it is immaterial. Similarly, you have the ability to control the composition of the board, whether you have done it or not, it is again immaterial. But with that ability itself, that other party becomes your related party. Then question comes about related party of Ind AS 24. This is slightly exhaustive definition. In fact, I have requested the Kinjal Mehta, who is Atul Bhai's daughter. She is a chartered accountant and company secretary also. She have good knowledge about accounting standards. So I requested her to make a presentation on the accounting standards, because as company secretaries, we have to have a fair amount of an idea of these two standards, not only for the purpose of the related party definition as far as the listed companies are concerned, but also you have to ensure that as a company secretary, it is also your responsibility to reflect the related party disclosures in your financial statements. So that's why with all due regards, if you ask the company secretary fraternity, very few people read the Ind AS 24 and the AS 18. So that's why we thought that why not to give a comprehensive presentation, so that a fair amount of an idea we will be having by the participants also. It may happen maybe next week or so. That we will announce, of course. So now the related party definition under Ind AS 24 is a related party is a person or entity that is related to the reporting entity. That means your company for which you are determining the related parties. a person or a close member of that person's family is related to a reporting entity if that person has control or joint control of the reporting entity, has significant influence over the reporting entity, is a member of the key management personnel of the reporting entity or of a parent of the reporting entity. That means when the control and exercising significant influence, it is there more or less as per India's 80, sorry, as per AS 80. The third component, what has been added is if the person is a KMP of the reporting entity or of a parent of the reporting entity, that means holding company's KMP and the KMP of the company are also related parties. An entity is related to the reporting entity if the following conditions applies. The entity and the reporting entity are members of the same group, which means that each parent subsidiary or fellow subsidiary is related to other than fellow subsidiaries. If as a holding company, I am having subsidiaries, say for example, 10 subsidiaries, all these 10 subsidiaries among themselves also, they become related parties. One entity is an associate or joint venture of the other entity, or an associate or joint venture of a member of a group, which the other entity is a member. That means if any associate or joint venture of the other entity, that means if they are having a common, what's called as in a group, and the joint venture of the company to that thing or associate of a particular company, that means if I am having joint venture with A and B also becomes related party to each other. Both entities are joint ventures of the same third party. So one entity is a joint venture of a third entity and the other entity is an associate of the third entity. The entity is a post-employment benefit plan for the benefit of employees of either the reporting entity. I think instead of I am explaining this in this particular webinar, let us focus upon some on the questions also. So when Kinjal is going to present these two standards, she will go into details of this. So now let me come to the essence of the related party definition. The definition under the Companies Act is explicit. Definition under the Act is not covering the promoter even till date also as a related party. As I told you that maybe if the promoter is exercising control or significant influence, maybe it is coming. Sorry, they are accustomed to act as per the instructions of the promoter, it is coming, but otherwise not. Under AS 18 and India AS 24, definitions are extensive. Under accounting standards, the definitions covers, as I told you, all direct and indirect subsidiaries, enterprises under the common control, and enterprises over which any key managerial person or other relatives exercise significant influence. Listing regulations prescribe a much broader definition of related parties, covering the entire above aspects what we have discussed so far. So now this effective April 1st, 2022, the definition of related party transaction is also changed. What is the changes and all we will discuss in detail maybe in the next webinar when we discuss about related party transactions. But for the understanding purpose of related party as such, one thing we have to understand is that post the change, related party transactions inter alia means a transaction involving a transfer of resources, services, or obligations between a listed entity or any of its subsidiaries on the one hand, and a related party of the listed entity or any of its subsidiaries on the other hand. So with this, what is happening is, in view of this revised definition, the following transactions shall fall in related party transactions. Transaction between the listed entity and its related parties, transactions between subsidiaries of listed entity and the related party of subsidiaries. This is anyway, it is already there in existence as of now. If the listed entity is dealing with its related parties, or if the subsidiaries are dealing with its related parties. In future, if the listed entity is dealing with the related party of the subsidiary, or if the subsidiary is dealing with the related party of the listed entity, that also is getting covered. The transactions between fellow subsidiaries are also getting covered as related parties. So what are the nuances of this definite change and all those things we will discuss. But the only purpose is that, is this diagonal transactions have any effect on the definition of related party. So here also what happens is that because of the change in RPT definition, what we have to do is that identify the related parties as defined under section 276, identify related parties as defined under rule 21ZB, and identify related parties as accounting standards. This is I am talking about 23-24 financial year for listed companies as well as unlisted companies wherever it is applicable. Because please remember that you have to have the audit committee approvals, because where that is prior approvals are required. As on 1st April, you have to have the approvals of audit committee, then only you will be able to transact the things. So most of the times what we will do is in the month of March meeting, if you convene separate meeting, or some companies, smaller companies, they take it in January meeting itself, that omnibus approval. When you are taking such approvals, you have to ensure that determination of related parties are happening based on this. What you have to do in case of listed companies is you have to give the list of related parties to your subsidiary companies, and you have to also procure the list of related parties of your subsidiaries. I'm talking this for the listed companies. The listed companies have to give its related parties to its subsidiaries. Why it is? Because you have to ask the subsidiaries, if you are dealing with these parties, then I have to ensure some compliances. Please let me know. At the same point of time, you have to also procure the list of related parties from all the subsidiaries, because if I am having any dealings with them, again, I need to ensure the compliances, especially the audit committee approvals are required. So the company secretaries are to be very proactive for the financial year 23-24 because of this change in the definition of related parties and related party transactions. Prepare a list of related parties at global level, that means at the company level or the group level, you may call it as, covering list of related parties of listed entity as well as of its subsidiaries, and track the transactions and ensure necessary compliances. One question I have been asked about because of this, one question I have been asked is, what is that the changes in the compliances of subsidiary companies? Because most of the time the subsidiary companies are unlisted group companies only. Are there any changes? There is absolutely no change in the definition of related party as far as the unlisted subsidiaries are concerned. They are continuing with that the related party definition under section 2 subsection 76 only. There is absolutely no change if they are unlisted companies. But sometimes it may so happen the subsidiaries are also listed companies. If subsidiary is a listed company, then no doubt about it, that change on the definition of RP is going to be there. Similarly, there is no change in the compliances to be made as far as the unlisted subsidiaries are concerned. The only additional thing what the subsidiaries have to do is that they have to report all the related party transactions, whether they are with their own related parties or they are having transactions with the related parties of the listed entity. They have to intimate to the listed entity. Because sometimes what happens is the transactions of the subsidiary companies are also to be approved by the audit committee of the listed entity, where the transactions of the subsidiaries, either of its own or of its listed entity, that means related parties, if it is more than 10% consolidated turnover till 31st March 2023 and 10% of the standalone turnover or 1,000 crores, whichever is less, then audit committee approval of the listed entity is required, and that approval is also a prior approval. So hence, I reiterate that as far as the unlisted subsidiary companies of the listed company is concerned, there is no change in the definition of related party. There is no change in the compliances what the subsidiaries have to ensure as far as the related parties are concerned. The only thing what the subsidiary companies have to do newly is, which they might be doing for the financial year 22-23, because certain changes have already come from 1st April 2022. What they have to do is they have to report all the transactions with the subsidiaries, whether it is of its own related parties or of its related party of the listed entities. They have to intimate to the listed entity so that the listed entity will ensure its compliances. Thank you very much for your patient listening. Now we can discuss the questions, whatever they are.
Whether the GST amount should be included, excluded, calculating 1,000 rupees turnover of the RPT transactions.
Go as per your P&L account, whatever the figure is there in the turnover.
Yeah, you are absolutely right. As per the annual financial statement, what is disclosed, that's all. Will the foreign subsidies is considered under the RPT for not being covered under the subsidy definition and also not covered elsewhere? Also, whether the related party of the foreign subsidy be covered under the RPT provision, foreign subsidy is getting covered due to managerial control provision.
Vallari, because you are the guest faculty, first of all, you attempt all the questions, and wherever it is, I have to intervene, I will. Otherwise, if at all, by any chance, if you want me to answer it, also you could pose it. Otherwise, it should not happen that I am dominating you.
No, not at all, sir. Not at all.
So please, all the questions of Professor Bala is to you first, then to me.
No, that's absolutely okay, sir. I think you're the stalwart and you're expert on the subject. But I think this is a very pertinent question that we are also facing, that the subsidiaries would include foreign subsidiaries. And then identifying the related parties for foreign subsidiaries is a challenge because there is no standard definition which may apply to these entities. So at least at our level, the call which we have taken is in case there is any definition of related party as per the local laws, we would align the related parties according to that definition. But if in case for any jurisdiction there is no concept or a definition of related party, then we would refer to the accounting standards and identify the related parties, because it would not be appropriate to align the definition under Companies Act for the subsidiaries, for the foreign subsidiaries related parties. So that's one point I think I can answer on this question.
Vallari,
Similarly, I have also, yeah, sorry, Bala. Yeah, go ahead.
Vallari, I fully agree with you, because when you talk about the foreign company, they are no way, covered under the Indian laws, because they are governed their own laws in where they are incorporated. So as you rightly say, we'll have to go by that if there is a concept of related party. But at the same time, since the financial statements are actually prepared based on the accounting standard, which is applicable universally, either AS 18 or Ind-AS 24, whatever it is, to that extent, yes, your answer is absolutely correct. I am in 100% agreement with you. That is what we were also used to do earlier. Yeah.
Right. Right.
Our foreign subsidies also covered. We talked about that. Whether the E-form MGT 8 should have detailed parties which are listed in the balance sheet as per the AS 24.
Which form? E-form MGT 8?
MGT 7 they are talking. That means secretarial compliance, I think.
MGT 7 is the annual return. So
yeah, annual
I'm
return.
sure annual return will, yes, sir. So I'm sure that carries the list of all promoter group, but that is with respect to the shareholding of the promoter group. So I don't really see a correlation between the list of related parties and reporting under MGT 7. I think those are two independent provisions and compliances. Sudhakar sir, if you can throw some
Yeah,
light
I agree with you. I
agree with you 100%. It is nothing to do with it. It is not at all featuring there. Whether the MD, who is a promoter of the company, can vote resolution on his appointment as MD.
So I think, yes,
in the
Sudhakar
board,
sir, you will also.
No, in the board meeting, naturally he is a concerned person. Okay, so he cannot participate in that board meeting on his own appointment. Others have to vote. Actually, that is there. Because in fact, when we are putting the appointment, he says that who's having an interest on his thing. We write there actually, and the memorandum of interest we are actually clearly showing here.
Right. No, I think that's absolutely right. For the board approval, certainly he's director who's concerned or interested and should not participate. But the question when it comes to shareholders approval for
general meeting.
Yes, in the general meeting, which is where my understanding is that if you refer section 188, it would have to be taken to the shareholders only if it is not in the ordinary course or not at arm's length basis. An appointment of MD is certainly a matter of ordinary course of business if a company has to appoint MD, and hence it will not be covered. More per se, if you see the may not be explicitly said, but as I understand the scheme of law, if there is a specific provision that prevails over a general provision. So since the appointment of MD is governed by section 196, which has its own mechanism of appointment, 188 particularly about a related party transaction where the appointment of a person to the office or place of profit will not prevail. Again, Sudhakar sir, if you have any expert views on this.
See, that I would like to say only one thing, as you rightly said, Vallari, that as far as the appointment of managerial persons, especially managing director, manager are concerned, before his appointment, when he is being appointed for the first time, only after his appointment, he becomes a KMP and a related party, not before that. So anyway, question of compliances at the time of his appointment for the first time doesn't arise because he is not a related party at all. Once he is appointed, no doubt about it, all the future the increments and other bonuses, etc., are concerned, whether they are related party transactions. Answer is yes. They are related party transactions. Now the question is that, are they triggering that 188? 188 only as far as the managerial persons are concerned, officer place of profit is there. And officer place of profit means what, other than what a director is entitled for, if he is getting anything that gets covered under officer place of profit is concerned for the managerial persons. So according to me, 188 as such is not required, but no doubt about it, audit committee approval is required, NRC approval is required, and board approval is also required, but not under 188, but under 197. So now the question comes that again the shareholders approval also. So what normally shareholders do is they give an approval in the beginning itself, whatever the remuneration limits are there, and they authorize the board or the NRC committee to determine from a year-to-year basis.
Right.
So similarly, as far as the audit committee is concerned, as I told you that every transaction which related party is to be approved by the audit committee. So prior approval of the audit committee is required. Right. Now the question comes, does it require every year whether I have to go to the audit committee for the related parties, your remuneration and other things are concerned? It all depends upon how you are structuring it. Okay. So for example, the audit committee as well as the NRC may fix a band for the KMP salaries or other PLIs and other things and authorize the managing director to determine it from on year-to-year basis. So not because what happens is that audit committee approval is a prior approval. NRC is a recommendation. They have to also decide and recommend to the board. Then board has to approve it. So for all these things, you may not be able to hold the meetings just for the small issues. So what happened is the companies have to decide and determine, number one, in the remuneration policy itself, you give some guidelines. In addition to that, whenever you are giving specific approvals, they have to give approvals in such a way that you decide, determine it and give it, authorize the managing director or CFO, whoever it is the persons, that within the given approvals, they will determine and finalize it, right? At the same point of time, as a good governance measure, maybe the subsequently, once it is determined what is going to be given to the XYZ people and all, the KMP's benefits as well as the senior management functions benefits and all, it may be placed before the respective committees as well as the board for the purpose of noting. This is only as a good governance measure. As such, there is no requirement also for this.
Right. Sir, as you rightly said, it depends on how the companies are structuring the approval process for the managerial remuneration specifically. So I think if the audit committee is approving the limits within the prescribed statutory limits itself, even without putting any numbers, I think that also suffices because law itself gives you a certain cap or a limit. And if that is being complied, I think no number also may be specified. So even in case of the omnibus approval for the year, any remuneration paid during the year within the applicable caps or as approved by the shareholders, I think that should suffice.
Correct.
If a body corporate is not holding more than 10% of financial year 2022-23, it holds more than 10% in April 23, whether he was considered RPT. I think we discussed elaborately this. Whether the transfer pricing transaction be considered RPT or not.
See, transfer pricing guidelines is only, we will discuss in the future webinars, but transfer pricing guidelines, you may take it as the basis for determination of arm's length transactions.
Arm's length price.
As far as the price is concerned, yes.
Correct. Arm's length itself cannot be. Anyway, we are going to have a future seminar on that. It will be discussed.
Correct.
Right.
Does clearing entities holding shares beyond 20% on behalf of the multiple folios shall also be considered a related party? I think clearing agencies
Sir, I
say they are
think,
not.
yeah.
They are holding on behalf of somebody in the normal course of business. They will not be covered under this. A director is paid the remuneration is now proposed to be appointed as a CEO. In addition to the remuneration, he is also paid the CEO remuneration, whether he should be under the place of profit.
What?
A director is paid a remuneration. That means he will be a whole-time director. And he is proposed to be appointed as a CEO. He is paid additional remuneration to be paid as a CEO, whether this would be under place of profit. I think I'm not very clear on this question because the director.
See, only thing is what we can presume is a director is being paid remuneration means he was an employee of the company who has been taken as a director on the board. The moment he is appointed like that, he will be deemed to be the whole-time director of the company. And definitely his remuneration is to be approved under 197, whatever the approvals are there. Now, when you are designating him as a CEO, it is only a mere designation. That's it, a change in the designation.
Correct.
Whatever the additional remuneration you are giving it to him, it amounts to some kind of a change in his remuneration. And because he is a related party, what we have discussed just now, your 177, 178, 197 approvals are required by the respective committees as well as of the board.
Nehal, it's okay. The question is answered. In case of the unlisted public company, whether promoter will be considered as the RPT?
I think sir clarified that it is.
Yes, sir has already discussed. He has already discussed elaborately on this.
Yes.
A director's son is a supplier and is supplying the goods in the company in the routine manner. Such a contract are not required to be reported to the board.
No, why should they not be reported?
He's a
very well a related party.
He is a related party. Obviously, he is a related party.
Yes, absolutely.
Because the relationship actually comes as per the list which is provided by the Companies Act.
Yes. So in fact, I think, sir, in the beginning itself said that there is no prohibition on the transaction. The related party transactions are not bad. It's just because there is a relation which presumes that the person may take any undue advantage of the position, and hence there is a governance mechanism and there is obviously a disclosure and transparency. So once that is followed, if that person is doing the transactions on in the ordinary business itself, it's absolutely fine. It should be approved by the audit committee and then taken up as the routine business. But yes, there is a governance mechanism required that should be followed.
Yeah, you are right. Because, so long as it is in the arm's length and as well as the normal course of business, okay, but related party is the related party transaction because he is related. Okay.
When he's a regular.
Yeah.
Sir, I have a point in our earlier question you have replied regarding related party of 10%.
Okay.
If somebody is holding only a single day in last year, he will become related party from 1st April 23.
Yeah.
But suppose someone is holding first time 10% in the month of April, he will be related party for next year.
Yeah,
and but that should not be the intention of the law, because once he is holding 10% throughout the year, he can do any transaction without confirming becoming related party. Because this year the limit of last year given, because a 10% limit is coming from 1st April 23. But once 1st April 23 comes, thereafter the day any shareholder holds more than 10%. According to my view, he should be related party from that day onwards. Otherwise, he can do any transaction throughout the year without affecting the limits.
Manoj, you have to read the law the way it is drafted and the way it is enforced.
No, but whether that is the intention of the law, because then that person can do any transaction throughout the year.
Answer is yes, you can.
Yeah, in fact,
the thing is, the way it is drafted, it said that 10% holding at any time in the previous financial year. So you have to go as per the law only.
See, you got a valid point. I agree with you. What you are saying, a valid point. You are right, actually. But the problem is, as Sudhakar puts it, somehow the law drafted has been done that way only today as it stands. Maybe the regulator realizes they bring the amendment or notification. We don't know. That could be happen because that always happen. Because anything which is implemented, soon after we get, there is an amendment, there is a notification, there is a instruction, all those things follows. Maybe we can expect that also in this case.
No, in
Maybe
fact,
because-
that is the reason probably that the threshold is brought down from 20% to 10%. So that there could be more such entities, more such persons, if at all applicable, who are holding shares and who could be in the position to influence. I think the logic, what point you are saying is valid. The person may be holding in April and then obviously having business transactions throughout the year as such. But the intent could have been that at the end of the year, you determine in case there have been any such persons or entities. Now, it is quite likely that any such person entities holding the shares purely on investment basis. But there could be few entities who are holding shares at the same time, who may be having any business relation or other transactions. But yes, rightly said, this is the law as on the date, so we'll have to comply with it.
Correct.
I don't agree.
Where the holding and subsidiary associate JV companies are covered under the definition, a body corporate is only includes the foreign companies.
Sir, I didn't get the question, please.
He says, where is the holding and subsidiary and associate JV companies are covered under the definition, as a body corporate only includes foreign companies. Can we hear from you, Mr. Rupal? If a KMP of a holding company is director or subsidiary company, and if the KMP fetches the salary in the holding company, then whether subsidiary company is required to take approval under the RPT.
KMP is a KMP in the subsidiary as well as holding company.
Yeah.
Okay. And drawing the remuneration. Yes, of course, the person will become a related party. And then there will have to be compliances ensured.
Holding and subsidiary private companies having the common director would be able to avail the exemption, which does not consider the holding and subsidiaries or RPTs by the definition. I'm not clear what is exactly the question. I'll read again.
Sorry, sir. I lost your voice for a minute.
Yeah.
Now you're saying holding and subsidiary company are
Holding and
both private limited companies.
holding and subsidiary private companies having the common directors, would they be able to avail exemption which does not consider the holding and subsidiary company to be RPT by definition?
Sir, I think there are two concepts. Transaction between these two companies would get exempt, but if the directors are having any transaction with those respective companies, there won't be any exemption. That will still have to be considered as a related party transaction.
Yeah, because exemption is given between the holding company and the subsidiary company only. I think so. Yeah.
Yes, yes. Holding company and a wholly owned subsidiary,
Yeah,
not
wholly owned
just a
subsidiary
subsidiary.
company. Yeah, wholly owned
So that's
subsidiary
where,
Yeah.
yes, right.
Please clarify applicable with the RPT to the private companies in relation to exemption notification MCA in June 2015.
See that, what I suggest is that this particular webinar we have convened on based on the related party definition only, not on the related party transactions.
Okay, we will discuss in the next.
Our next webinar, which is going to be on the related party transactions.
Okay.
So that point of time, let us discuss all the nuances and the interpretations of the uncompliances of the related party transactions.
Right.
Then you will appreciate that. Otherwise, you may not appreciate whatever we may say here.
Yeah, right. If wholly owned subsidiary company services of the holding company received 100% turnover, then related party transaction treated or not? Please clarify.
Sir, I think there are more questions on the transactions.
Transaction, I think we will avoid. I think transaction we won't avoid.
Right,
We will go only by the consent. Okay.
Right. But I think, sir, there was one interesting question, and that was one thing I wanted to touch upon.
Yeah.
From April 1st, 23, when there is additional requirement of identifying transactions with unrelated parties who could be passing on the benefit to a related party. And while the legislators have put in a condition or a requirement, it's very, very difficult to practically follow to identify these kinds of transactions.
You're talking about the purpose and effect.
Yes, the purpose and
The
effect is to
transaction with
benefit
a related party. I mean,
Yes.
The purpose and effect of a transaction with an entity which is causing a benefit to the ultimate related party.
related party. Yes. So
So for
which
that,
is where
Vallari,
I
you have to
think,
attend our next webinar then. Either as a faculty or as a participant. There we will discuss
choice,
it in
sir.
detail.
That's your choice. And I think, yes, this just one amendment needs in-depth discussion, because there are multiple angles to it, multiple scenarios, in fact, hundreds of challenges. Because as I said, I think the legislators have just put it across with the intent, or maybe with the cases that they had recently observed. And I think this came in particularly from the ICICI and the Vodafone transaction that happened, that while the transaction was with an unrelated party, and then nobody could have foreseen that the benefit was actually going to a related party, which is what they are intending to capture. But how to practically give effect to this amendment, or to ensure we are thinking about it, I think we are still trying to check what kind of confirmations we can internally take, validations we can take. But at the same time, I think I agree, this needs a complete different 2-hour session to discuss in detail. But that was one question I just came across. I thought maybe we can just touch upon the topic.
It is definitely going to be
Though we will discuss that at the next, whenever we will be discussing about RPTs. But one thing is there, that the purpose and effect of that RPTs to the ultimate beneficiary. If it is no doubt about it, it is difficult to track those transactions, maybe for the company secretary, because company secretary may be aloof about those transactions. Sometimes even the CFO himself may be aloof. But if it is a structured transaction, the person who is structuring the transaction will certainly know it. And he will definitely be a senior person in the company itself, whether at a board level or a KMP level, that is a different thing altogether. So anyway, that I have some thoughts about that particular this thing, that we will discuss it in the coming webinar, where we will be discussing the related party transactions. No doubt about it, Vallari, it is a very significant thing which is coming from
you raise a very, very valid point. It is a very, very tricky issue. It is going to be great practical difficulties in it. That is going to be the case. Okay. Body corporate includes only foreign company and other companies. This I think you explained actually when you say the body corporate replaced with the word company, you said actually. And the public company or the both the condition should be fulfilled. That also we discussed, the related party 10% put together himself or two things.
See, just 1 minute, Bala, something has come to my mind, that recently in one forum somebody asked me that a director is a director in some companies, and he has not given the disclosure. Subsequent, then what will happen, and how as a company secretary I am responsible for that. So no doubt about it, as far as the company secretary is concerned, when you are determining the related parties list, definitely based on the information what have been provided by the directors only you will go. But at the same point of time, my advice to all the company secretaries is that we should not do mere postman job. Once the information comes to us, we have to also cross-check that information. Say, for example, if I am a director, I have given you that I am a director in say 7 companies. And on if you go to the MCA portal, I am a director in 10 companies. As a company secretary, you have to cross-check that, and you have to ask me, by that you have disclosed only 7 companies, whereas you are already a director in 10 companies. So it is the responsibility of the company secretary. Only don't depend upon the information what you have been provided with. Wherever and whenever you can cross-check it, please do that. And if there is any discrepancy is there, you have to get it clarified from the director concerned. Because sometimes it is the responsibility of the company secretary to take care of the interest of the directors also. Unconsciously, he might be giving that what's called as the information which he is thinking that to the best of his information, it is right. Say, for example, he might have resigned on a company. That company might not have filed the necessary DIR 12 with the ROC concerned, and his name is still continuing to appear there. And this director is not aware of that, by that they have not filed the necessary form. So you have to tell the company that, look, you might have resigned it, but that company is concerned, they are still showing your name as a director in the MCA records. So please do the needful. So these kind of issues are also there.
Okay. I'm not taking any transaction-based question. I'm going by only concept here. For AS also, subsidy is not provided, and we have to refer Companies Act or subsidy definition. No, AS is talking, na? AS 24 and the Index talking the relationship separately. In case of the joint venture company, not required to have an independent director on their board, not constitute the audit committee. In such a scenario, who will approve the RPT? If the committee is not there, automatically it goes to the board, I think. That is there. With effect for 1st April 23, in case of the
one minute. See, 1 minute. Wherever, of course, we will discuss again the same thing. This is a transaction-related query.
Yeah.
But suppose, for example, the prior approval of the audit committee is required, and the audit committee is not there.
Yeah.
That not unlike 135, wherever the CSR committee is not there, that responsibilities are to be discharged by the board. That kind of requirement is not there under 177. So that's why whether by default, whether the board has to look after all the things, that needs to be examined. We cannot say per se the board will discharge the responsibilities of the audit committees. Answer is no.
Okay.
Okay. We will discuss that when we will go with the RPT, this thing, because there is a difference between 135, the way that it was used. It says that CSR committee need not be constituted. However, the responsibilities of the CSR committee will be discharged by the board. That kind of wording is not there wherever audit committee is not in existence. So, in fact, if audit committee is there, you have to have 177 gets triggered. If audit committee is not there, then what happens is for that company, only 188 is there. Whatever the 188 compliances are there, you have to do that. Okay.
Okay.
Exactly, sir. In fact, the approvals under 177 apply if you have audit committee, and it's audit committee's responsibility to review and approve those transactions.
Correct.
If you read 188, it clearly says transactions except with the approval of the board. So the requirement of related party transaction is board's responsibility to approve. Obviously, when companies have the audit committees, the additional responsibility is entrusted on them.
Any different view in case of the entity of CIC, NPSC governed by RBI?
See, whether it is, sorry, Vallari, you can take it.
Right. No, I think there a couple of points will apply is specifically the investing company concept, because the associate or the investments because of the CIC or NBFCs which are into investments, that could apply. Otherwise, any entity or any company which is either a listed or unlisted, depending on the specific definitions, the related party will have to be captured. I don't think there is a different definition. I only understand the RBI guidelines do define a group, which as such is not a concept defined anywhere in Companies Act or accounting standards. But that group also is for the purpose of considering an entity to be CIC in terms of the investments held by a particular NBFC. I don't think it reflects the transactions with other companies, because even if with other companies and within the group, the criteria will have to be as per either Companies Act or the accounting standards.
I think
now let me add further to that whatever Vallari has said. Number one, NBFC companies, they are companies for the purpose of Companies Act, so they have to ensure that whatever the compliances they have to ensure as far as the Companies Act is concerned, that is to be done. Over and above that, if your company is regulated by any other regulator, maybe an IRDA for insurance companies, RBI for NBFC companies, okay, similarly telecom companies are there, TRI is there for them. So like this, if any specific regulator is there and he is prescribing some regulatory norms, over and above the Companies Act compliances, you have to ensure those compliances also. So now for the purpose of group, for the Companies Act, it may be different. For the listed companies, it may be different. Group definition for NBFC companies, it may be different. So whenever you are complying with that regulatory requirement of that particular regulator, you have to ensure that the definitions also accordingly.
Yes.
Okay. So, and then question comes that suppose if I have to comply both with Companies Act as well as with the listing regulations as well as with the regulatory norms, which one I have to comply with? Whichever the compliances which is there on the higher pedestal, that you have to comply with. Suppose Companies Act might have given exemptions, but listing regulations have not given you that exemption, so you cannot avail that. Similarly, Companies Act and listing regulations might have given you exemptions, but that regulatory norms of that particular regulator have not given you the exemption, so you cannot take that exemption. So the regulatory mechanism of the whichever is there on the higher pedestal, that compliance you have to ensure it.
Then again,
Right, sir, absolutely.
there is a question again, the purpose and the effect that anyway we are going to discuss in the next meeting, so we are not taking it. Remuneration paid by the listed holding company to its employer, who is also a director of the subsidiary, whether any approvals will be required.
So this also is an RPT only. We will
This
discuss
also
it.
RPT we'll talk about later. I am a old-time company secretary and my husband purchased the product and get the discount is the related party. So again, transaction basis. Then the next question also is a transaction. There are a lot of questions only on the transaction. I think probably with all these transaction questions, we'll take it later. Section 276 of the Act of the Director, other than the independent director, a key managerial person of the holding company or his relative with a reference to a company shall be deemed to be a related party. Please elaborate.
Yes, sir. I was also just reading the same question.
Yeah.
So essentially, all the directors of the entity and their relatives, KMP and their relatives, are considered as related parties for that entity. In addition, what is as per the last subclause as may be prescribed, there is the rule which says that the directors other than independent directors or KMPs or their relatives will, in addition to all of these criteria, be considered as a related party for that entity. So that's where this gets additionally covered. Now, there is a slight overlap, or I wouldn't say overlap, but provision is having overlap, but contradiction as well. Here, in case of a holding company, it is a director other than independent director to be considered as a related party. Whereas accounting standards, when we look at the concept of KMP or a key managerial personnel, it says a person who could be in the control of management or direction, such as the directors, whether executive or otherwise. So from the accounting standard perspective, all the directors are considered or covered. Whereas, of course, of the holding company or not, those specific nuances of the subclauses will have to be checked. Whereas this is a difference in the concept and definition. I hope I've answered your question.
If a person is a director, if the person is only director or only manager in the public company, but does not hold any shares, will he be related party in that public company?
Now, I think sir clarified that very well. The shareholding is an important criteria. Both the conditions should be satisfied. The person has to be a director, and the second condition is has to hold more than 2%. Of course, that more than 2% could be individually himself or along with his relatives. So even if that person or that director is not holding any single share, but the relatives are holding, the first condition being satisfied that he's a director and the shareholding criteria is met, he will be a related party. But if either of the criteria is not satisfied, the person will not be considered as rather that entity will not be considered as a related party in this case.
Yeah, Mr. Sudhakar has very well explained this concept actually. Absolutely. Really in the beginning. Yeah. A CAC company having the audit committee, whether should comply with the requirements of section 177 as per the Constitution.
I think sir just elaborated that
just only he spoke.
Exactly. It's the company that compliances for related party, which we will have to ensure.
Yeah.
So company having audit committee, obviously, yes, there is applicability of 177. and the transactions will have to be approved. But I think that was very well clarified by Sir.
In fact, Vallari, there are under the RBI, the private company and public company both can be registered under the RBI registration. But once you register the private company under the RBI registration, as per the RBI registration, because it being a NPSC company, it is required to have the audit committee. But as per the Companies Act is concerned, audit committee is not the requirement. But the NPSC companies, audit committee is required. But the law says very categorically, once you appoint the audit committee, once you constitute the audit committee in the private company, all the provisions which are applicable as per the audit committee provision, as per the Companies Act will apply. So that means,
sir, not only that, Bala sir, let me also tell you, suppose sometimes even if you constitute the audit committee voluntarily,
yeah,
still you have to comply with 177 compliances.
Yeah, then also it is applicable. Then also it is applicable. Because why I gave the example, in the NPSC company, there is a specific provision. Even if it is a private company or a public company, audit committee will be required. But under the Companies Act, private company is not required to have the audit committee. But the moment you constitute the audit committee there, all the provisions applicable to the audit company as per the Companies Act is applicable here. So here CIC also, I don't see any exemption. Once the audit committee is there, it has to comply with everything meticulously. That is the thing.
Right. So it's in the same line as our secretarial standards provide. Even if you voluntarily appoint independent directors, if not required to be appointed, you will still have to comply with the applicable provisions with respect to independent directors. It's the same way. If you have voluntarily formed a committee, you will have to comply with the applicable requirements.
Applicability of the RBT to the government company.
So my understanding is Companies Act does not exempt government companies, but the listing regulations have exempted transactions of government companies. So from that perspective, they get an exemption. But from the Companies Act perspective, they will not get the exemption. Sudhakar sir, if you can.
I agree with you. I agree with you.
I think that's all we are done with the questions here. Leaving the transaction question. Transaction question we will discuss only next time.
Right. So I think this was quite elaborate discussion on the related party concept or a definition itself. And with the changes that happened in the last 2 years, particularly the change in shareholding threshold we discussed about, even now that the concept of related party, which earlier used to be only revolving around the reporting entity or the entity for which the related party is to be identified. Now, even the related parties of subsidiaries will have to be identified for further looking at the compliances or the disclosures. I think the concept of related party itself is widening, and we all have to be alert on checking that from time to time on a periodic basis. I think that's where we also internally need to build that checklist or a confirmation, either with the related part, either with the subsidiaries or even through the shareholding. I think that's going to be a lot more activity and compliance for us, but a good mechanism or a good governance required in the long run. Over to you, Bala sir.
I think Rupal Narvekar wants to say something on this.
Right. Sir, I think Sudhakar sir has dropped off.
Yeah.
I think thought that he has dropped off.
Okay. Rupal Narvekar, are you there?
Yeah.
You can speak.
Hello, sir.
Yes.
Yeah, actually the question was when I attended one seminar of WIRC, and when I asked the speaker, she said the body corporate includes only foreign company. So my question is, body corporate should include all the companies like private, public, for the definition of the related party 276(7). 8. So that's why I got confused whether this body corporate includes only foreign company or all the private companies, public, foreign company. Because of that, all the companies would get covered, associate, joint venture, subsidiaries, and investing.
Rupal, my understanding is that it includes all the companies. The inclusive concept for a foreign company, or rather, I will avoid using the word foreign company, a company incorporated outside India, is what is specifically added with the concept of body corporate. Sudhakar sir, you want to add on this question?
What was the question? I got disconnected again. I got reconnected, so I missed out.
Right. So she was asking, or rather, Rupal, if you want to ask the question again. Sorry.
Because the question was actually whether only body corporate means is only the company which are incorporated as a foreign company, or whether it will include all the companies, private, public, and other companies. That was her question. Because probably she seemed to have attended some other seminar where they said it is only a foreign company, not the other company. That was her question actually. I
Yes,
think,
sir.
yeah.
No, it is not the foreign company. It is the word they have used is the body corporate. So whichever is falling under the definition of body corporate, all of them get covered. Because foreign company definition under the Companies Act is entirely different.
Right, so that's why I avoided saying foreign company. It's company incorporated outside India. That's a
Absolutely.
different one.
So let us use the word body corporate because body corporate is defined under the Companies Act.
That is right.
And
body corporate is really a wider term. If you talk the foreign company, it acquires a different color actually.
Absolutely. Foreign company is very limited. The definition of foreign company is a limited definition for the purpose of some compliances in India. It is coming.
Is LLB is a body corporate is a question.
Sir, I think, but her question was in a way valid that conceptually, if you see the definition under Companies Act, the body corporate is just saying body corporate includes a company incorporated outside India. Now, when it says includes, should it be interpreted that it includes company incorporated in India as well as company incorporated outside India? Or should there be a specific language saying that body corporate means a company incorporated in India and includes one incorporated outside India as well? I'm not talking about the other exclusions, but in terms of inclusivity.
See, companies incorporated under the Companies Act in India are also body corporate only.
Sorry, sir. Sorry, I lost your voice. It includes.
No, what I'm saying is that companies incorporated under the Companies Act here in India, they are also part of body corporate. Body corporate is a very wider definition. So it includes companies. It includes companies incorporated in India.
Is LLB a body corporate? I think answer is yes. LLB is a body corporate.
Yeah.
I think that is all the questions I have here. I think barring that transaction question, we have taken up all the questions. Anybody has got any other questions at this point of time? Sudhakar, one thing is there, very, very creditable, because even at this particular hours, I can see more than a century people are still there. Because the question is, the topic is so important and so diverse. It is very complicated. Any number of times you start reading it, you get the different new meaning every time.
Sir, in fact, I said in several forums that the most abused some key terminology is one of that is in the ordinary course of business. Okay, in the ordinary course of business, in fact, I can speak for 1 hour. What exactly, how to determine the ordinary course of business? Because if I am the regulator, if I come to your company, you might have taken it in the ordinary course of business and arm's length. But I must say it is not in the ordinary course of business. You have to prove that. If it is a listed company, of course, anyway, your job is a little less because anyway, you are not claiming that exemption. But in case of listed companies also, definitely they are having their group companies, and wherein this ordinary course of business, that that key terminology, which is not defined under the Companies Act, is a very important aspect. And same is the case with arm's length. People take arm's length means only the pricing is important. Arm's length doesn't mean only the pricing. There are several other factors are there. So that's why I thought that let us also discuss the key terminology as far as the RPTs are concerned, which is equally important for us, which we will do it definitely.
I think Harsha has raised the hand. Yes, Harsha.
Sir, Harsha here. Thanks for giving this opportunity. I have a question which is not particularly related to say RP or RPT. Can I ask an unrelated question?
Yeah,
yes,
tell us.
Yeah, so sir, this is regarding a joint venture. Suppose if there is a joint venture where my company is holding 60%, so it is a 60-40 joint venture, and there is an agreement in place, so it is definitely a joint venture. But then under the Companies Act definition, it also becomes my subsidiary because I'm having 60% stake there. Then for that particular entity, whether provisions with regard to appointment of independent directors and then having an audit committee and NRC will be applicable for that particular joint venture or not? That I am actually currently dealing with.
So see that if number one, this question is not related to RPT, right?
Correct,
Your
correct. It's
question is
absolutely not related to RPT.
yeah, correct. So now your question is that it is a subsidiary company. Whether
Yeah.
appointment of independent directors is required or not required and all, please refer to 149.
Okay.
Because you are a subsidiary of a listed company, is it required that you have to appoint independent directors or different parameters are there? Right.
Okay.
So Harsha, what I want to is that there is a revised guidance note and independent directors is there.
Okay.
Okay. So please read that. So
Sure.
you have to do your homework first before getting the answer from us.
Sure, sir.
Okay,
Sure.
please
Thank you
do
so
that.
much.
Still, if there is an issue, you can call me at any point of time. Then I will answer. I will clarify you that. Or even Bala sir may also clarify you that. But I always tell these days, people normally earlier what used to happen, they used to just call me and I used to give them the answer. Nowadays, I stopped doing that. I say, first of all, even in my own firm or earlier in my company also, if anybody brings a problem, I always say that, first of all, do your homework. You come to your conclusion. What according to you, is it required to appoint independent directors or not? If it is so, based on what? After that, I will clarify whether you are right or wrong. If you are wrong, I will say why you are wrong. If you are right and why you are right. The rationale I can explain you at that point of time. Okay.
Sure, sir. I'll do my homework. I'll read 149 and the revised guidelines on ID and get the answer.
Thank you.
Sure,
Thank
sir.
you, Harshna.
Thank you so much, sir. Thank you.
CEAT 2013 is passed after LLB Act. Then why it is not including LLB definition in the body corporate? There it include corporation, society, etc.
No, it does not include. It rather excludes from the definition of body corporate. Isn't that so? Have you got the answer? It's not include. I mean, it's not specifically stated because it is inclusive. The definition carves out what is not included as a body corporate.
Correct. You are right, actually.
Yeah, I think Bala sir, I think it is 120.
Yeah, I think we should close this. So last one, we'll read that. For the deemed related party, we have to check 10% of the shareholding of the proceeding financial. But if any person is holding 10% more shareholding, I think this we have talked about it actually. This question was raised by
right. Even if in the current year the person is holding more than 10%, that person or entity will be considered as related party for the subsequent financial.
Yeah, that is right. That we discussed. I think that's all. I think it's already time is up. We are overshot the time. It is already 1:20. So I think Sudhakar, you have done a very, very excellent, elaborate presentation. Definitely speaking, lot of things which actually came out. Because lot of interaction, lot of things which actually prove, and we had a excellent sharing knowledge from the Vallari. So I must personally take the opportunity for thanking you on my own behalf and also on behalf of the participants to you for the excellent job. Thanks to all the participants for talking to us, interacting to us. It is really a knowledge adding session. Hope to see you in the forthcoming seminar. I think with this, we close the session. Thank you. Thank you all.
Thank you, sir. Thank you very much for this opportunity once again. And thanks to all the participants. Thank you, everyone.
Thank you.
Thank you.